I will note that this will be perhaps the last in a long series of AI hearings before several pieces of legislation will be marked up. Either we win in innovation and we win in AI, or we lose our edge on the international stage.
Common law is crucial to the protection of Americans because it exists no matter whether there are comprehensive state laws on the books or no laws governing new technology on the books. Even when there are no statutes, common law helps us set a floor for a standard of care as a society.
And it is my firm and considered opinion that denying states the ability to regulate novel technology issues going forward would be a grievous and avoidable error.
So I encourage members on both sides of the aisle to make sure that this panel of witnesses are asked questions that may be germane to proposed legislation or legislation already offered. I now recognize myself for an opening statement. Literally a generation ago, or in technology, 10 generations ago, a sharp young man graduated from Cal State San Marcos in my congressional district. He joined a company that I then was CEO of, Directed Electronics, which had an inherent inventory problem. The inventory problem was that we had a few SKUs that sold well and we managed, and hundreds of SKUs that were constantly either out of or oversupply of. It wasn't anyone's fault. We had simply grown quickly, and there was a certain amount of inconsistency in what was being sold in a given month. So that bright young man took all of that inventory and the records and put it into SuperCalc, a precursor to Microsoft Excel. Within weeks, we had reduced our out of stock, increased our same-day delivery, trimmed inventory to a level that actually saved us over $1 million a year in inventory maintenance cost. That bright young man continued to work at the company for many years. He did not continue to use SuperCalc for long because technology quickly gave better and better tools. The man, the program, the machine, both are necessary to implement and make AI a reality. But it was the man who made the machine that made the man a success. Over the last century, the U.S. has led the way in virtually every area of technology because of our pro-innovation bias. We are the innovators. Well, China are the duplicators, and Europe, yes, are the regulators. As we speak, though, my home state of California, with an economy larger than that of Italy, is rivaling the European Union when it comes to trying to lead on regulation. This wouldn't be such an ironic occurrence, except we are the home of innovation and, yes, the new bastion of regulation. But just as in the 1990s, when America led the internet revolution, a light touch, such as that offered by the president in his initiative, in fact, must be the direction we go. Anything else will give us a problem that I will describe. If we, in fact, are not innovating 10 times faster than we're regulating, if the speed of innovation in the U.S. is not at least months or, if possible, years ahead of China, their speed of duplication, some of it actually using AI to duplicate what we're doing, will, in fact, cause us to lose our edge. My home state is part of the problem. The European Union is part of the problem. But as you'll see from our witnesses today, all 50 states have implemented some form of AI regulation. And in fact, there are in the neighborhood of 1,000 pieces of legislation spread over 50 states that will create, if allowed to continue, a patchwork of indecision by the AI industry. Given conflicting regulations, given the inability to roll out with certainty technology, that technology simply will not be a priority. Let there be no doubt, though, either we win in innovation and we win in AI, or we lose our edge on the international stage. Vice President Vance said it best: America's AI technology must remain the gold standard worldwide. We must continue to produce the next generation AI, and we cannot do it with a patchwork of conflicting state laws.
When I drive from Georgia to Washington, D.C., about once every 6 months or so, and I get a chance to listen to the radio and scan and listen to all my favorite stations and tunes, you know, I've got to pass through 3 states. I go through Virginia, go through South Carolina, go through North Carolina, and then I hit Georgia. And we all have had experience in crossing state lines before. And you'll have different speed limits and different levels of enforcement. You have the experience of figuring out what are the rules. So in other words, because you're going 79 miles an hour at the state line, and then flip to another state, and boom, all of a sudden the speed limit is 65. So you've got to then do, 74 to stop from getting pulled over, and hope that that officers won't stop you. But anyway, when some suggested earlier that we in Congress should preempt all state AI laws, they would not just have done away with states' nascent generative AI consumer protections, they would have preempted common law causes of action against AI companies as well. When the doctrine of caveat emptor, or buyer beware, ruled American jurisprudence, consumers had minimal protection and were expected to thoroughly inspect products themselves. Judicial interpretations began to change in the early middle 20th century as products became less straightforward and more complicated. Common law developed to better protect consumers in products liability and negligence cases. Today, most Americans can hardly imagine taking apart a toaster, let alone an AI chat box, to make sure that it works correctly. But caveat emptor is effectively what advocates of a moratorium are suggesting we revert to when we talk about an AI moratorium. When you preempt an entire field of law, you're preempting the common law right along with it. Supreme Court law has repeatedly found, as it did in Regal versus Medtronic, that a federal law's reference to a state's requirements includes its common law duties. And in plain language, that means if Congress preempts state AI laws, we also preempt state common law, unless the legislation explicitly says something else. Common law cases to protect consumers are already being filed against generative AI platforms. 2 days ago, Senator Hawley held a hearing on the harms to children using AI technology, calling witnesses whose children died or were hospitalized after interacting with artificial intelligence chatbots. I know some of the parents and families are in the room today. Kristen Bride, Juliana Arnold, Mandy Furness, and Megan Garcia. I'm so sorry for what you all have been through, and I admire your commitment to justice. Common law is crucial to the protection of Americans because it exists no matter whether there are comprehensive state laws on the books or no laws governing new technology on the books. Even when there are no statutes, common law helps us set a floor for a standard of care as a society. When some of my colleagues across the aisle talk about a moratorium, preempting common law is exactly what they're talking about. Carve-outs might be offered for some areas of the law. Others may get a loose regulatory structure. But what many don't realize is that the glue that holds the law together would be wiped out in almost every scenario. By protecting common law, we can protect that floor that ensures every person harmed can seek to have their case heard before a court of law. This basic standard of care can spur innovation by preventing a race to the bottom.
My message here today boils down to one simple point. Congress needs to act promptly to formulate a clear national policy framework for artificial intelligence to ensure our nation is prepared to win the computational revolution. If we get this wrong, the consequences could be profound in terms of geopolitical competitiveness, national security, economic growth, small business innovation, and human flourishing. Unfortunately, America's AI innovators are currently facing the prospect of many state governments importing European-style technocratic regulatory policies across America. As you noted, Mr. Chairman, more than 1,000 AI-related bills are already pending across the nation. But some states are far more aggressive and influential on national market outcomes than others. Almost 50 AI-related laws are currently pending in California, and New York is currently considering almost triple that number. Sacramento and Albany should not be dictating AI policy for the entire nation. That approach is especially problematic for so-called little tech innovators who will struggle with confusing, costly compliance burdens. America would not have become the global leader in digital technology it has if we had had 50 state computer bureaus or even a single California Computer Commission allowing to license every single aspect of interstate computing and treat the internet as a regulated utility. Thankfully, America avoided that fate because of wise bipartisan decisions that this Congress made in the 1990s, which let digital technology be born free as opposed to being born into a regulatory cage. Laws like the Telecommunications Act of 1996 and the Internet Text Freedom Act of 1998 included important provisions, preempting and facilitating a national digital marketplace. The U.S. is now the global leader in almost every segment of computing and digital commerce, thanks to this wise policy approach. Now is the time for Congress to work the same magic for AI by creating a national framework to prevent a patchwork of state mandates from undermining AI innovation. Colorado Governor Jared Polis has called upon Congress to preempt state AI laws, such as the one his own state passed last year, and he has even endorsed the idea of a state AI regulatory moratorium like the one Congress considered this summer. Other governors have raised similar concerns. Connecticut Governor Ned Lamont has warned of, quote, every state going out and doing their own thing, a patchwork quilt of regulations, he said. And just last week, New York Governor Kathy Hochul noted how, quote, it's hard when one state has a set of rules, another state does, and another state. I don't think that's a model for inspiring innovation, end quote. Congress could again try to implement a moratorium, or it could formally preempt specific state and local regulatory enactments that impose an undue burden on interstate algorithmic commerce. If Congress chooses the latter option, federal lawmakers should first preempt state regulations of AI frontier models because the costs associated with such regulations would outweigh any local benefits. Such rules would create spillovers and undermine development of the system the nation needs to compete globally. State officials also lack the technical expertise and information about national security matters that could be relevant to AI safety considerations. Second, for issues related to so-called algorithmic bias or AI discrimination, Congress should preempt state efforts to regulate the development of AI systems and applications through cumbersome and confusing mechanisms such as AI audits or algorithmic impact assessments. To the extent any such ex-ante regulations are imposed, it should be done at the federal level, and existing federal civil rights laws and non-discrimination standards should apply. Finally, Congress should also require the National Institute of Standards and Technology and the new Center for AI Standards and Innovation within NIST to oversee a new standing AI working group to coordinate and work to resolve other federal state AI policy matters. NIST and CASI could help devise more workable, consistent standards for AI policy matters not already preempted by federal law. Even where the scoping of federal preemption proves difficult, everyone should agree that AI development will be discouraged if America has dozens of different definitions of key concepts. Inconsistent standards will undermine market certainty and hurt investment, innovation, and competition. Ongoing congressional oversight of this process will be essential, and Congress can simultaneously consider what sort of new light touch rules might be necessary at the federal level to address various AI safety concerns. Meanwhile, state governments still have a role to play and will have plenty of room to act using a diverse policy toolkit of generally applicable laws to address any real-world harms that might come about from AI applications. In closing, the time has come for Congress to exercise its constitutional responsibility to protect the interstate marketplace and the national interest in the development of robust AI capabilities that will ensure the United States remains at the forefront of this technological revolution.